The ACLU isn't the only group raising the alarm about the technology. Earlier this month, Microsoft, MSFT, President Brad Smith posted an unusual plea on the company's blog asking that the development of facial recognition systems not be left up to tech companies. Saying that the tech raises issues that go to the heart of fundamental human rights protections like privacy and freedom of expression, Smith called for a government initiative to regulate the proper use of facial recognition technology, informed first by a bipartisan and expert commission. But we may not get new laws anytime soon. The nuances are complex, while Congress remains as reluctant as ever to regulate privacy. We may find ourselves stuck struggling to agree on norms well after the technology has redefined everything from policing to marketing. Or as Nicole Turner-Lee, a fellow at the Brookings Institution in Washington, put it, we live in an economy of images. Or facial recognition may come as a choice subject to your own calculus of convenience versus privacy. If you value streamlining air travel enough, you can join such experiments in biometric identification as a test of facial recognition boarding at LAX. Or it can be beyond your control. Maybe your state shares its driver's license database with other government agencies. A 2016 study by the Georgetown Law Center's Center on Privacy and Technology found that at least 26 states had opened those databases to police searches, covering the faces of more than 117 million American adults. Or the passport control checkpoint at an international border where you already have minimal rights may demand you look into an automated camera. The problem is you can't assume to know when a camera and its software identify you, that their recognition algorithms are accurate, or that the underlying databases are always secure. As Microsoft's Smith noted, those conditions usually lead to government intervention. What should that look like? Turner-Lee and Michigan State University professor Anil K. Jain agreed on some basic principles. In a December corporate blog post, Facebook Deputy Chief Privacy Officer Rob Sherman wrote that most people would find it easier to manage one master setting. But those principles still allow for enormous flexibility. For instance, does a government or company have to identify what databases it uses in its facial recognition regime? An announcement last week from Governor Andrew Cuomo, of facial recognition scanning at some New York bridges and tunnels said nothing about that. And how long should a camera feed be kept around? Some police departments already set surprisingly short limits for footage not classified as crime evidence: 30 days in New York, 10 business days in Washington. And for now, processing power limits long-term archival. As Jane said, the cost of storing is not that much, but the cost of searching could become prohibitive. But history suggests those limits will keep expanding. Because the consequences of a false positive can be so much higher in a law enforcement context, we may first only see rules for government use. That proposed bill, however, doesn't cover commercial facial recognition. Individual cases brought by the Federal Trade Commission could help set some norms, Turner-Lee said, but she doesn't expect comprehensive rules. I don't think we're anywhere near any type of regulatory or legal framework, she concluded. And considering how ineffectual Congress has been on privacy issues, even a bill covering just police use might be too difficult. Meanwhile, the cameras will keep getting plugged in. Jane pointed to China as one example of what technology left unchecked could make possible. They say by 2020, there will be 600 million surveillance cameras in China, he said. You will be covered no matter where you go. More from Rob. Email rob@, follow him on Twitter at @RobGuerrero.